Hello, my name's Rick Bigwood. I'm the Dean of the Law School here at UQ, and I also teach into the Master's Coursework program. My course is Advanced Studies in Contract, and I've been teaching that for a few years now. And so, as the name of the course suggests, Advanced Studies in Contract, and so it does have intellectual content, of course, because it is a Master's course. But in designing the course, I start with the premise that most of the students in the course wouldn't have had a structured learning experience in contract law probably since their first year in law school. So there's a significant revisory component to the course, and so essentially the course is a survey of almost the entire landscape of contract, but focusing on particular areas that arise in practice, or particular problematic areas where lawyers would wish to advise their clients to avoid problems. And so the course is chunked, if you like, over 4 days, and each day is sort of dedicated to a particular segment in the very linear subject that's contract, starting with formation of contract, the phenomenon of agreement, through to the content, discovering and trying to understand the meaning of the terms, and then we move through to the performance phase of contract, and the concept of performance and breach, and the possibilities of termination for serious cases of breach and repudiation, and then we transition through to enforcement. What makes agreements, contracts, of course, they're enforceable, and contracts enforced through remedies, and so we look at the various, or the principal kinds of remedies, some of the nuances around the remedies in relation to enforcement of the contract. In the very final day, we look at really what's the opposite of enforcement, and that's vitiation. The contract, where there's a problem in the formation or the legality of the contract, there's some defect discovered, and what impact and remedial response the law recognises for that. But sort of day one, we're going back to the start, is around formation issues, problems with agreement. Not all simple offer and acceptance stuff, but we do discuss that, important consideration, for example, around, problems with informal contracting, when parties sort of accidentally, what are called, drift into contract. We also look at the impact of the increasingly developing law of estoppel on contract and contractual relations and contractual activity. That's something that a practitioner can't avoid nowadays. And we look also on day one at the similar phenomena in relation to contract variations, around particularly informal contract variations, and some of the pitfalls to avoid there. On day two of the course, and I should mention that the course is taught intensively over two weekends over the semester. So on the second day of the first weekend of the course, we look at contract terms. So the terms obviously are what give the contract its content and define the scopes of obligations assumed by the parties under the agreement. We spend quite a bit of time talking about how one identifies the content of the term. Obviously they're expressed terms, but there's lots of learning around contractual implication, or perhaps whether terms can be inferred. And we spend a bit of time as well on the parole evidence rule, which particularly looking at ways to circumvent the parole evidence rule, so one can bring extrinsic evidence in to beef up the content of the contract by oral terms where there are written terms as well. We speak a little bit about contract interpretation, not an awful lot, because that will trespass on the territory of another course taught in the LLM on contract and statutory interpretation. But I do talk a little bit about the interpretation of some problematic clauses, exclusionary or limitation clauses. We look briefly at the law of unfair contract terms as well. And so you'll go away for a while and you'll come back a few weeks later and we'll do the second chunk of the course in the second weekend. And day one there is around what I call liability issues. And so we look at the concept of performance and breach, and we spend quite a bit of time on issues around terminating a contract and some of the pitfalls to do there, because a wrongful termination, of course, very suddenly becomes problematic. And we also look on that day at remedies, specific performance damages and the like. And as I mentioned at the start, the final day we look at contract vitiation. There's many ways in which a contract can be made defective in some way. It could be for basic illegality or public policy, but an awful lot has to do with the vitiation of the consent that's been brought to the transaction. So we'll look at a lot of contract doctrines that regulate the authenticity of the consent brought to the contract. So hopefully that's of interest to folks, and hope to see you enrolled in the course. Bye.